Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon, Council. We're proceeding this afternoon first in the case of United States versus Juan Angel Velasquez Canales. Lyston, are you ready?
Yes, thank you, Your Honor. May it please the court, Jenny Lyston for Juan Velasquez. Your Honors, this appeal requires you to answer two questions. First, what do the guidelines mean by the term suspended sentence? And two, was Mr. Velasquez's sentence suspended? We believe that it was, and that the district court therefore erred in applying the 6th level enhancement under 2L 2.1 B3C. So what is a suspended sentence? The courts that have looked at this question agree that a suspended sentence is, quote, a sentence postponed so that the convicted criminal is not required to serve time unless he or she commits another crime or violates some other court-imposed condition. Courts likewise agree that the defining characteristics of a suspended sentence are: 1, the offender is released from incarceration, but remains subject to a postponed prison term. 2, such release does not arise through discretionary executive action. And 3, the released offender is under a continuing obligation such that if he offends, he will be, the postponed prison term will be triggered and he must serve it out if he violates. And yes, Your Honor.
Ms. Lyston, could you answer for us whether this is a question of North Carolina law that we have before us here today, whether the defendant was serving part of his prison sentence when he was on supervised release?
So, Your Honor, North Carolina law certainly informs this court's decision, but this court does not, of course, defer to state labels to determine, to interpret the guidelines. And so we, of course, have to determine sort of how North Carolina treats these sentences, but we don't defer to how North Carolina characterizes such sentences.
Right, and the reason why I was asking the question was looking at Judge Motz's language in United States versus Barlow.
Yes.
He says that North Carolina places the time, and this is at page 138 of the opinion. She says North Carolina places time spent on post-release supervision within, not outside of, the maximum term of imprisonment.
Yes.
So that's what I was concerned with when I was asking you about whether we have an issue of state law here.
And so, Your Honors, if there's one thing I want to make clear today is that Barlow does not decide this issue. Barlow is a statutory interpretation case and dealing with the definition of a felony for purposes of 922G. To put it in the guideline context, and it wasn't a guideline case, but to put it sort of in the guideline context for today, Barlow is essentially addressing what is a sentence of imprisonment for purposes of 4A1.2B1. And if that were the issue today, if I was coming in here contending that Mr. Velasquez didn't receive a term of imprisonment of 17 months, absolutely Barlow would foreclose that issue. That's not the issue here today, though. It's a question of B2. Was any part of that term of imprisonment suspended? And we contend that it was when you look at the defining characteristics of a suspended sentence and then consider how that operates under North Carolina law. So when you consider those defining characteristics that I just talked about, the 9-month period that Mr. Velasquez spent on post-release supervision functionally operates as a suspended sentence. First, the offender is released from incarceration and for 9 months before the final termination of his sentence, and that 9-month prison term is postponed. And that's under NC Gen Stat 15A-1368.2. Second, that release is mandatory under the law. The statute mandates it, and it is built into the court's judgment. It's not a discretionary decision. That release must happen. So it's not the governor calling up the Department of Corrections and saying, I want to pardon Mr. Velasquez. It's not the Department of Homeland Security saying that we want to deport him, so we would like you to release him. It happens through the court's judgment as a matter of law. The offender, importantly, cannot...
Excuse me, doesn't that argument cut both ways, though? Because ordinarily a suspended sentence is something that's subject to the discretion of the court. But if something has to happen, generally that's part of the term of imprisonment, isn't it?
So, Your Honor, I believe respectfully, I would disagree that to qualify as a suspended sentence, it must necessarily rest with the discretion of the court. I agree with you that it does have to be imposed through the court, but it's not necessarily just because the court, at least the cases that I have read, don't talk about that this must be a discretionary decision by the court or else it doesn't qualify as a suspended sentence. It is implemented. It's the court's judgment is implementing state law. And so that's why I say it's sort of baked into the judgment. The court doesn't have to say, yes,
Can I follow up with that just to make sure I understand your point? You
Yes.
gave the 3 conditions that you believe make a suspended sentence. And the second of them was in the negative, right? That it may not involve the discretion of the executive.
Correct.
Right. And I think I gather, and I understand perhaps that what Judge Keenan is getting at is that we naturally think of suspended sentences instead of being not the executive's discretion. We think of it as an affirmative, that requirement really captures that it is the discretion of the sentencing judge. And so what's the authority? I understand you say generally that this is what the cases say, but what is the best authority that I can look at that would point me to say that second element you've identified is the negative about the executive as opposed to the affirmative discretion of the sentencing judge? That's the point of this that I'm having trouble with. I think of it as the sentencing judge's discretion as being what is it, the core aspect of a suspended sentence, not the lack of executive discretion. So what am I looking at to convince me on that?
So, Your Honor, I don't think I can point you to any single case that says that it affirms the negative as I have posited it, as opposed to the positive. I will say this: I'm not the suspension of the sentence here. I think what's important to realize is that the only thing that places Mr. Velasquez into the custody of the Department of Corrections is the state court judgment. And by the same token, the only thing that releases him from that state court, from the Department of Corrections, is the state court judgment. No one else is involved.
That's not right. So just to be clear, that's actually incorrect, because what takes him out of prison is the state court judgment and a state statute. Right? Is the operation of the state statute is what takes him out of custody, not the operation of the judgment. If the judgment said, 4 years suspended to time served, right, then that's the judgment that's taking him out of prison. But what you have is a statute taking him out. It's not the judgment that's taking him out. It's a statute.
So, Your Honor, respectfully, I would say that the state court, the only thing that the Department of Corrections is going to look at to release Mr. Velasquez is that state court judgment. Because the statute mandates it, the only thing they're going to look at is, okay, how much time did the state court judge give to Mr. Velasquez? Okay, this is how much time he got. And we know by operation of law that's built in to this judgment, into this sentence, we know that he has to be released 9 months prior to that time. So, yes, Your Honor.
Were you finished? You go ahead if you weren't.
No, I'm finished. Thank you.
Okay. Ms. Lesson, if you look at North Carolina General Statute Section 15A-1351, it talks about suspended sentences and says that the court may suspend the term of imprisonment and place the defendant on probation. Well, that's not what happened here.
Your Honors, I believe that
the term of imprisonment, as you say, the term of imprisonment was defined by law, and it wasn't a discretionary act of the court suspending any part of that term and placing the defendant on probation.
And Your Honor, I do not dispute that there were other avenues by which a court could suspend this sentence. And I think that's a red herring. I don't think the issue today is whether there are other ways in which North Carolina, a sentence can be suspended under North Carolina law. What we're looking at today is simply whether this particular method basically functionally operates as a suspended sentence. And we believe that it does. And it's not happening through any other avenue other than the state court sentence and the state court judgment.
Can I ask a variation on that as well? Mm-hmm. So I understand your point that North Carolina's law is informative but not controlling. As Judge Keenan just pointed out, the 1351 says the court may. In other words, the court has the discretion, and that's what makes the suspended sentence. Are you aware of any other state that defines suspension of a sentence without reference to what the court may in its discretion do? So in other words, does anybody else use the phrase suspended sentence to cover what we're talking about here? I understand maybe North Carolina's doesn't control, but if everybody else uses it in the same way, then that starts to look like very powerful evidence of what suspended sentence actually means, doesn't it?
So, Your Honor, I mean, I will say that the courts looking at this issue when determining whether or not a sentence is suspended, they don't limit themselves to considering only whether or not the state court actually said this was a suspended sentence. And I provided the example of the Salazar-Balsadua case in which the court considered whether or not under Kentucky law, whether the conditional discharge amounted to a suspended sentence. And there the Fifth Circuit said, yes, it did, because basically Kentucky law treated this more or less as a suspended sentence. And even though the district court, or even though the state court didn't call it that. So I don't believe. Can I go back to,
okay, I understand the premise, but on the factual question, are you aware of any state that defines suspended sentence like North Carolina does in 1351 to be something other than the discretionary act of the sentencing judge?
No, Your Honor, I'm not aware. So, Your Honor, I understand the court's concern here, but when you look to North Carolina state law, the way that it operates, this 9-month period operates as a suspended sentence. Importantly, the time spent while on post-release supervision, the offender gets no credit for that time towards that postponed prison term. So they can be released and serve 8.5 months on post-release supervision. And if at that 8.5 month mark, they mess up, they're going to go back and serve the entire 9-month period. So I think that just goes to show that this is not some sort of alternative means of serving the sentence. This is a postponed prison term, and it arises through the district court's judgment. No one else, no action by the executive interferes or causes that release of the individual to post-release supervision. And we've already talked about how just because North Carolina doesn't call it a suspended sentence doesn't necessarily doesn't bind this court's hands in determining whether or not it is in fact a suspended sentence. When the court imposed that 6 to 17 month sentence, it knew that Mr. Velasquez was going to be released the 9 months prior to the expiration of his sentence. So it didn't need to put anything into the judgment that said okay, the final 9 months, he's going to be released, because again, it operates through the function of law. And so if he had wanted Mr. Velasquez, if the district court wanted Mr. Velasquez to serve a longer term of active incarceration, it could have, within a certain amount of discretion, imposed a longer sentence to ensure that he received a longer active term of incarceration, of actual incarceration. So again, Your Honor, I would just contend that it's the fact that it is not necessarily a discretionary decision by the judge, that it operates through North Carolina law, doesn't mean that this is not a suspended sentence. Your Honors, we believe that when you apply those defining characteristics, that you will find that this is a suspended sentence. And unless this court has any other questions, that's pretty much my argument.
All right, thank you, counsel. We'll hear from Mr. Bragdon now.
Thank you, Your Honor.
And then you'll have rebuttal time after this.
Thank you, Your Honor.
Good afternoon. May it please the court. My name is David Bragdon, and I represent the United States in this matter. Based on a couple of the questions asked, I wanted to first highlight that North Carolina does have a standard system for suspending sentences, and it is different from post-release supervision in two key ways. The first ways, as this court has noted, is that in suspending a supervised release sentence, that is done completely through the judge. So the judge decides to impose a suspended sentence. There's some discretion based on the type of felony the defendant has, his criminal history, and in some cases an active sentence is required. In a lot of cases, the judge has a choice as to whether or not to impose an active sentence or a suspended sentence. Similarly, when it comes up for revocation, that is also completely done by the court. The revocation process has to come back to the judge. Oftentimes it's the same judge, and that whole process is done by the court. In contrast, the administration of post-release supervision is done by the executive. It's the Post-Release Supervision and Parole Commission that administers it. This was talked about some in the last part of the Barlow decision. But by operation of law, it's not any decision by the court, but it's by operation of law that this 9 months is set, and any revocation, any change, the conditions themselves, all of that is done through the executive. The second important distinction that yes, Your Honor.
Second one, your colleague gave the example that on a 9-month release that we have here, at month 8.5, if there's a violation, that the law provides that violator can then be put back in prison for 9 months, as opposed to only the time remaining on the sentence. Is that your understanding of how this works? I may have just been misunderstood. I just want to make sure I understand the structure. I was under the impression that it's only the time remaining on the maximum sentence, so that if you violated 8.5 months, you can only go back to prison for 2 weeks. Am I misunderstanding that?
Your Honor, I do believe that Ms. Lyston is correct on that point. It surprised me as well, but when I looked at the statute, and I'm sure we could, I don't have a citation handy in front of me, but when I was reading some of the commentary, it did say that when the parole commission is revoking that condition, they can give any of the unserved sentence of imprisonment. And so in a sense, if the defendant has served 5, 6, 7 months of their post-release supervision, the court may still impose up to 9 months imprisonment. So that is factually accurate. So the second thing I wanted to point to is I think this court has emphasized the importance of looking at the judgment. And we see that in Barlow, where they look at the judgment for what kind of sentence there is. And in this case, North Carolina has two separate judgment forms. It has a judgment form for a suspended sentence. It has a judgment form for an active sentence. And the court can see examples of both of these when it looks at the record in the Barlow case. And I've got the references to the joint appendix in the Barlow case if the court wants them, but both of those types were in the record there. And on the suspended sentence judgment, it is entitled, and let me just make sure, I get this exactly right, but it basically specifically says that it's a judgment for a suspended sentence. And it then specifies that the sentence that's listed is suspended and the defendant is put on probation. Yes, Your Honor.
I just want to clarify one point that you made and make sure I understand. Let's say, taking Ms. Lyston's example, that someone is out on post-release supervision and after 8 months violates the terms and conditions, okay? Who imposes the time back on him? Did you say that it was the parole commission that does that, the executive?
The parole commission, Your Honor.
Okay, so it's not, the court has no role in deciding whether to reimpose that term?
That is my understanding, Your Honor. There is discussion of that in Barlow, and I've reviewed the statutes. And it does appear that it is the parole commission. Initially, there's a preliminary hearing before the parole commission that provides, they find probable cause, which lasts 45 days. And then there has to be a hearing before the parole commission where they would then decide whether or not to revoke the post-release supervision.
So you're saying that the trial court under North Carolina law plays no role in the revocation of post-supervision release, or post-release supervision?
That is my understanding, Your Honor.
Okay.
It does not play a role. And that makes it very distinct from a suspended sentence under North Carolina law. And I think in Ms. Lyston's reply brief, she does note some of these courts and other circuits that talk about the importance of the judicial role in imposing a suspended sentence. And I think if that's true, if we accept that as the appropriate framework, it matters here that really this is being administered by the executive, it's being revoked by the executive, as opposed to supervised release under North Carolina law, which is done through the court system. The other thing I'll mention, and I would like to, there was an unpublished decision that came out in May that we did not cite in our brief because it came out after our brief came out. But it's United States versus Gonzalez Ferrites, and it's 813 F Appendix 837. And in that case, the court addresses a Pennsylvania situation where the Pennsylvania court had sentenced Gonzalez to a minimum term of time served and a maximum of 23 months. So similar to here, there was a minimum and a maximum, but as part of the judgment, it also granted immediate parole as a specific condition. And so it was clear from the Pennsylvania court's decision at sentencing that the defendant was going to be released. And so the defendant argued that his immediate parole was a suspended sentence under the guidelines and shouldn't be used in calculating the guideline range. And like the defendant here, he argued that it functionally qualified as a suspended sentence. He said the court's order created no possibility that he would serve a sentence over 13 months in prison. But the court rejected that argument, and it said, we're looking at the minimum and the maximum that are in the judgment. And we see no basis to accept the defendant's argument that the functional effect of a sentencing order, rather than the language used in the sentencing judgment, defines a suspended sentence under the guidelines. This court then went on to compare the parole to a suspended sentence under incarceration under Pennsylvania law. And they said, well, parole is a conditional release from sentence, while probation is a suspended sentence of incarceration served on such terms and conditions as imposed by the sentencing court. And so it found that distinction mattered. And I think there's similar distinctions here between North Carolina suspended sentence and North Carolina post-release supervision. The other thing I'll mention is when the North Carolina court imposes a suspended sentence, it also suspends post-release supervision. So if you say that post-release supervision is a suspended sentence itself, then you have a suspended sentence within a suspended sentence, which I think would be kind of odd. I think it makes more sense to see post-release supervision as something different. I think Barlow is important because Barlow teaches us that we look at the judgment and we look at, and the judgment is important, and how the state characterizes and defines the sentence is important. And here North Carolina found that this post-release supervision was part of the term of imprisonment. At this point, I'll take any other questions that the court has, but if there's no further questions, I will rest on a brief and ask the court to affirm.
All right, sir, thank you very much. Ms. Lyston, do you have rebuttal?
Yes, Your Honors, thank you. Judge Richardson, you had asked about that citation to authority for that the supervisee doesn't receive any credit. And I can provide that citation. That is NC Gen Stat 15A-1368.3 C2, which says the supervisee shall not receive any credit for days on post-release supervision against the maximum term of imprisonment imposed by the court. And so it is true as well that the commission does determine whether or not to send offenders back to serve that term of imprisonment. But I would also say that this court made it very clear in Barlow that going back and serving that postponed prison term, that is part of the original term of imprisonment imposed by the court. So it is, they're not going to prison for their violation. They're going to prison to serve out the remainder of their postponed prison term. And I would also point out that Barlow makes very clear that we do not allow North Carolina, we're taking North Carolina law into account, but we're not allowing the North Carolina labels to dictate this court's decisions. And because—
Can I ask a question on this point about the commission imposing some additional sentence? Does the statute indicate that the commission may impose up to the remaining time left on the maximum? So in other words, couldn't the commission impose, instead of the full 9 months, couldn't the commission impose 6 months or 3 months?
So it depends on the violation, Your Honor. So if the two violations trigger the full 9 months, and that's absconding or committing new criminal conduct. Lesser violations trigger lesser periods to serve on that term of imprisonment.
But the commission's making that decision under whatever sort of structure it wants to, which doesn't look exactly like it's sending it back to finish out the full term of incarceration. They're just making a judgment about how long they should go back.
But this court specifically said in Barlow, Your Honor, that when the commission does that, it's not doing that to to punish the person for their violations. They're sending them back to serve out the original term of incarceration. And, you know, in Barlow, the defendant, of course, was arguing that post-release supervision is supervised release. And this court said, we understand that North Carolina calls it post-release supervision, but that's not actually what it is. It is part of the term of imprisonment. And this court rejected the defendant's argument that that label, the way North Carolina called it post-release supervision, meant that it was actually post-release supervision. They said it fell within that term of imprisonment and rejected the label that North Carolina applied to it. So we believe that people on post-release supervision since they're not receiving any credit towards that postponed prison term, we think that's just one more reason why this operates as a suspended sentence and not, that it operates as a suspended sentence, Your Honor, under the definitions that we have provided. So we would ask respectfully, Your Honors, that you reverse the district court's judgment here and return the case for resentencing without the enhancement. Thank you, Your Honors.
All right, thank you very much, Ms. Lyson. And the panel would like to thank both counsel for your participation today. We know there's some logistical difficulties in making all this happen, and you've been a very important part of our success today. So thank you very much. We've enjoyed hearing you.
Look forward to seeing you in Richmond again.
Yes.
Thank you.
Thank you. Okay, we're ready for the next case then.
Erica Hashimoto from the Georgetown Law Center on behalf of Mr. Earl. With the court's permission and with Mr. Earl's consent, Olivia O'Hay, a third-year law student at the University of Georgia, will be presenting argument on behalf of Mr. Earl, and I apologize that my video keeps going out. There's the video. Thank you. And with the court's permission, Ms. O'Hay will present the argument now.
Thank you very much. And Ms. O'Hay, we're very pleased to have you. If you'd like to proceed.
All right. Is everybody able to see and hear me?
Mm-hmm.
The district court's grant of summary judgment should be reversed, and this court should grant a Bivens remedy for Mr. Earl's First Amendment retaliation claim. At the heart of that claim was a complete breakdown in the BOP grievance process. And it is that grievance process that safeguards all other constitutional rights and ensures that federal inmates like Mr. Earl have access to the court system. Prison officials weaponized this process against Mr. Earl when they placed him in the SHU mere days after filing a grievance. A Bivens remedy should be recognized by this court to redress that injury and ensure that federal inmates can continue to use the BOP grievance process safely and effectively. First, although this case presents a new context, there are no special factors counseling hesitation in First Amendment retaliation claims. Therefore, a Bivens remedy should be recognized by this court. Both Abbasi and Hernandez recognize that there is something unique about the federal structure, and that the issues in those cases, including immigration, national security, and foreign relations policy, are uniquely federal in nature. However, Mr. Earl's claim is a garden variety retaliation claim, the type that state and federal courts regularly hear day in and day out. It does not involve high-level government officials exercising executive authority, nor does it concern a broad policy question that will be entrusted to a coordinate branch. Instead, it is against low-level unit managers who made an intentional choice to violate BOP policy and Mr. Earl's constitutional rights. The issues in this case are simply categorically different than the recognized special factors. Moreover, Section 1983 retaliation claims against low-level state officials demonstrate that the hypothetical administrative burden on federal officials should not be considered a special factor. There are differences between state and federal prisons at a high level, particularly for officers with constitutional obligations. However, there is zero difference between what low-level state prison unit managers do and what low-level federal prison unit managers do.
Okay, Ms. O'Hay, it's not really just a matter of comparing the different remedies available, though, to federal and state. I mean, we've been admonished by the Supreme Court to not go adding additional Bivens remedies. I mean, the court was pretty specific. In the Abbasi case, the court is telling us that Bivens, in Ziegler, is telling us that the Bivens remedy is now disfavored in terms of adding additional remedies. Why is this so unusual and unique when there have really no court has ever recognized, and certainly not the Supreme Court recognized, a Bivens remedy in the First Amendment context?
Your Honor is correct that dicta from recent cases suggests that extending Bivens may be disfavored. However, both of those cases, Hernandez and Abbasi, do still use the two-step Bivens analysis. It is still good law. And the fact that this case presents a new context that would be a modest extension of the Bivens doctrine is not enough to stop the analysis. We must consider whether there are special factors counseling hesitation. And in this instance of low-level retaliation, there are no uniquely federal special factors that would implicate separation of powers concerns.
But isn't there a concern, though, with the prison ability system to run itself efficiently and to make decisions internally? And if you have federal prisoners going to court to sue every time they think they haven't been treated fairly in prison, doesn't this cause a disruption of the separation of powers and really take away from the executive the ability to place the proper parameters around the prisoner and the prisoner's activities?
Your Honor, the Supreme Court has never recognized that type of administrative burden as a special factor. And in fact, Carlson, which is good law, expressly rejected it, noting that federal officials and prison officials do not enjoy such independent constitutional status to insulate them from liability. Congress has created gatekeeping.
Right, excuse me, I'm not suggesting that they're insulated. I'm suggesting that don't you have a problem, just in the real world, not talking about factors or any particular case, but don't you have a real world problem if prisoners can go to court and sue every time they don't like how the system has treated them in terms of responding to their complaints? Doesn't that create an unworkable system? And how do we go about fashioning a rule that would cabin that so that it wouldn't get out of control?
Your Honor, the rule would be unworkable only to the extent that retaliation regularly happens, which I do not think the government is willing to concede. Here, this was not a day-to-day prison administration decision, and those types of decisions would receive the benefit of qualified immunity. Only those meritorious, non-frivolous claims would make it past both qualified immunity and the PLRA gatekeeping functions to get to this court. 1983, yes, Your Honor.
You were relying on Carlson, but Carlson was an Eighth Amendment claim. Do you have any authority to support your First Amendment argument anywhere in the country?
No, Your Honor. Federal courts in the country have not recognized a First Amendment retaliation Bivens claim.
Okay, thank you.
Can you, in that context, and in light of Judge Keenan's questions about the direction that the Supreme Court has been giving us on Bivens claims generally, can you talk a little bit about Bush versus Lucas, which is a First Amendment retaliation claim, and the Supreme Court fairly resoundingly rejected it, and understanding it's in a slightly different context, but help me understand if I wanted to ignore the Supreme Court's as you call it, dicta, I call it guidance. But I wanted to ignore that. What would I do with Bush versus Lucas?
Your Honor, what makes this case distinct from Bush versus Lucas is that the plaintiffs in Bush versus Lucas had an alternative remedy available to them through the civil service remedial structure. However, Mr. Earl—
Don't in there an administrative remedy process here that he could have gone through I can't remember the initials, APB or something, the administrative review where he could have had his classification changed and received his job back, and those remedies were available. It seems to me quite similarly to the administrative remedies available in Bush versus Lucas.
Your Honor, the BOP grievance process that you suggest Mr. Earl go through cannot provide an adequate alternative remedy for him because his complaint is that that process broke down and that he was retaliated against for using it as he should have and as BOP policy requests he does to file a grievance. And
but
so
you agree that, I mean, the court said that the alternative remedy doesn't have to be a perfect one, right? I mean, that was part of the argument in Bush versus Lucas, right? Is that the review process there was not as good as, you know, a new Bivens action would have been. Everybody sort of concedes that idea. The point is that if you have some remedy available, as they did in Bush versus Lucas, and as Mr. Earl does here, that is, call it a special factor, call it whatever you like, that's a strong reason that counsel's against expanding Bivens to totally new context where it's never been extended before.
Your Honor, the BOP grievance process in this issue just simply cannot provide a remedy for Mr. Earl's allegation because his claim is that the process broke down. And so in those very specific instances where the heart of the issue is a total breakdown in the BOP grievance process, the process itself cannot serve as an alternative remedy.
And where's the Supreme Court or any court said that where there is a problem with the system, that suffices to, you know, require that we make up a new cause of action under Bivens? I understand the impetus to say, oh, well, it wasn't working really well, so, you know, federal courts give me a better option. But why would I say that? What's the support for that idea?
Your Honor, while the Supreme Court has never discussed the BOP grievance process specifically, an analogous breakdown could be considered in Carlson, where there was a full breakdown in the provision of medical care and the administrative decisions involved to provide that medical care, or in that instance, withhold it. And there the Supreme Court did find a Bivens implied cause of action for that breakdown. Every case that involves a Bivens remedy acknowledges the central purpose that deterrence plays in granting that remedy. And retaliation is the exact type of behavior that should be deterred. Indeed, there is an important right at stake here. It is the principal guarantee of the Constitution. And when individual officers go rogue and violate this right, it threatens the very foundation upon which the BOP grievance process is built. There must be a way to protect this process from intentional interference, and the deterrent effect of a Bivens remedy is the key to that protection. If a federal inmate cannot trust the grievance process because they may be retaliated against for using it, they cannot vindicate any constitutional injury at the hands of a prison official. Moreover, if inmates cannot access the court system because they cannot file these grievances, then courts will have no way of knowing what type of unconstitutional conduct may be occurring in the prison system. It will frustrate the deterrent purpose of Bivens if courts have no way of accessing that information. Moreover, recognizing a Bivens remedy in this case is necessary to ensuring that Carlson does not become toothless. Permitting First Amendment retaliation frustrates—
Excuse me, you said to ensure that Carlson does not become what?
Toothless, pardon me, Your Honor.
Oh, toothless. Okay, but Carlson was extreme facts, wasn't it? Didn't somebody die from a lack of medical care? Didn't he have, did he have an asthma attack and didn't receive? I mean, so that's an extreme situation. And Carlson, I think the court rightly recognized there are just some cases that are so bad that there has to be a remedy. But why is that, you know, comparable in any way to the grievance of Mr. Earl?
Two responses, Your Honor. First, you are correct. The facts alleged in Carlson did involve a death. However, that is not the threshold question. And indeed, the BOP grievance process vindicates not only the Carlson right, but all other constitutional rights. And so it is critically important, although it did not involve a death in this case. The second response is that to bring a meritorious Carlson claim, and so that will be a claim that does not present a new context and does not have any special factors counseling hesitation, a claim to which someone would be entitled a Bivens remedy. It is necessary to exhaust your administrative processes first. And to do that, you must be able to file a BOP grievance. However, if this court affirms the district court's grant of summary judgment, it essentially sends a signal that it is okay to retaliate against inmates for using that process. How could somebody be expected to bring even a meritorious Carlson claim if, to do that, they face the potential of retaliation at the hands of prison officials? This case, involving First Amendment retaliation, necessarily implicates the important right in Carlson.
Can I ask a slightly different question? If we were inclined to follow your lead here and create a wholly new Bivens cause of action, is there any reason to think that it would be limited to First Amendment retaliation as opposed to other First Amendment claims? And I'm thinking a little bit about the recent Sixth Circuit decision refusing to create a Bivens remedy for First Amendment obscenity type claims. Is there a principle that you could point us to that would suggest that your proposed Bivens remedy wouldn't extend to all First Amendment rights in the prison context?
Certainly, Your Honor, and one need look no further than Carlson for an example of that. Carlson Bivens remedies do not extend to all Eighth Amendment rights. Rather, they are cabined to the cruel and unusual punishment clause. That's an example of how you can have a narrow First Amendment retaliation Bivens remedy without implicating the other clauses of the First Amendment.
What are the other Eighth Amendment? I mean, we don't tend to have excessive fines when you're in prison. I mean, what other Eighth Amendment claims would there be? I mean, you say it's cabined to the cruel and unusual provision, but what other prison claims would arise under the Eighth Amendment? Maybe I don't have it in front of me. I'm not sure what else the Eighth Amendment would include that might come up in a prison context.
Your Honor, Carlson specifically referenced excessive fines and issues involving bail. So, for example, a plaintiff would not...
Prison context, right?
Yes, Your Honor. So in this instance, a First Amendment retaliation claim would be the narrow claim that we are asking for use of the BOP grievance process. Carlson does demonstrate that certain clauses can receive a Bivens remedy while other clauses may not. And finally, when evaluating the special factors here, such as prison administration, it is critical and the court demands that we consider the right at issue against the proposed factor. Here, the right at issue is the right to safely use the BOP grievance process. It is indeed critically important. Not only is it a gatekeeper to the federal court system, but it is also how prison management is alerted to any potential unconstitutional behaviors. Prison management needs to know about these cases so that they do not, in fact, reach the courtroom. Moreover, the proposed special factor of administration was expressly rejected by Carlson. And so weighing these two interests against each other, it is clear that a modest and narrow extension of Bivens for First Amendment retaliation is specifically the type of deterrent remedy that Bivens was meant to provide.
All right. Thank you very much. We'll hear from you later on rebuttal. Is Ms. Reisenweber available?
Yes. Are you able to hear and see me?
Yes.
Thank you. May it please the court, Erin Reisenweber on behalf of the appellees. Your Honors, the appellees respectfully disagree that that Bivens should be extended to a prisoner's First Amendment right to be free from retaliation, as appellant argues today. Furthermore, appellant's heavy reliance on Carlson v. Green is certainly misplaced. 30 years have now passed since the United States Supreme Court decided Carlson, and during that time, as Judge Keenan noted, The United States Supreme Court has significantly become more cautious in any approach in expanding Bivens. As noted in their language in both Abbasi and Hernandez v. Mesa, the courts made it clear that if a statute does not clearly show Congress's intent to create a private right of action, that it certainly should not be then created by the judiciary. I wanted to note, as Judge Richardson made mention of, that this past July, the Sixth Circuit in Callahan, the Bureau of Prisons, did refuse to expand Bivens to an inmate's First Amendment right. As Judge Richardson noted, that did involve seizure of sexually explicit materials from the prisoner. But again, to date, there has been no expansion of Bivens to any First Amendment right anywhere within our court system. In the real world, appellees submit that there are numerous special factors that counsel against extending Bivens to the remedy that Mr. Earl seeks. First of all, it is our position that anytime the judiciary is asked to expand upon Bivens remedies, you're going to involve a situation pulling in separation of powers. Prison discipline and prison administration should be left to the legislative and executive branches. And Congress sought to do that in enacting the Prisoner Litigation Reform Act. Certainly, there will be a surefire increase in prisoner litigation should the courts expand Bivens to a First Amendment right to be free from retaliation for filing grievances. I would ask your honors to, at some point, take a moment and look at Joint Appendix pages 141 and 142. For that matter, take a look at pages 106 through 146, which comprise Mr. Earl's prolific administrative remedy filing during his time in custody with the Federal Bureau of Prisons.
Counsel, are you aware, did Mr. Earl file any grievance issues after the circumstances that give rise to this case?
Yes, Your Honor. Since that time,
you don't need to look it up.
I'm looking at least 5 pages, and that's just through 2018. I don't have up through the present day in front of me. Not just the courts, but BOP counsel, as well as other government attorneys, are already handling litigation through 2255s, through 2241s, through Federal Tort Claims Act cases, and of course, other Bivens actions from inmates. Mr. Earl is one of approximately 153,000 federal inmates. And when you add all of those up, this will certainly, any expansion of Bivens to this realm will certainly cause a burden upon many aspects of the government. I think that Judge Richardson's question about trying to limit an expansion only to this area of the First Amendment would be difficult and would set us along a slippery slope. I would see that any expansion to one area of the First Amendment, such as we're dealing with in this case, would then be used in an attempt to expand even further. although of course not binding authority in this case, one district, the District of New Jersey, has also held specifically in Rodriguez that retaliation for filing grievances regarding stolen property by an inmate, that the court there refused to expand Bivens to that First Amendment retaliation claim within the prison setting. And finally, in regards to the Bivens issue or the Abbasi issue, the appellees submit that certainly there would be a chilling effect if our corrections officers across the country are aware that they can be held liable for private damages in suits brought by inmates for this type of allegation. There certainly will be a chilling effect on those officers, which may then result in safety issues of those officers across the country. That is the appellee's position on the Abbasi portion of this case. With Your Honor's permission, I'd like to address some of the other issues within the case, although they weren't addressed in opening argument.
Are they, Counselor, are they only alternative arguments? In other words, if you prevail on the Bivens claim, do any of the rest of these issues need resolution?
No, Your Honor. They are only alternative arguments. In summation, in regards to the Abbasi argument, it is the appellee's position that this is not an area of the law that the United States Supreme Court, based on its recent holdings, would want Bivens expanded to. Their language has been clear in their most recent cases. No court in this country has expanded Bivens to a First Amendment claim, and the appellees request that this court affirm the holding of the district court. Thank you.
Okay, thank you very much. Ms. O'Hay, do you have any rebuttal?
Yes, Your Honors, 3 points on rebuttal. First, the fact that Mr. Earl continued to file grievances is not dispositive for a retaliation claim. Constantine informs us that First Amendment retaliation does not depend on the actual effect of the party in question. The test is not whether it froze that person's use of the grievance process, but whether it would chill a person of ordinary firmness. Surely the consequences here, being placed in segregated housing, being stripped of good time credits and a prison job, would chill a person of ordinary firmness, although it may not have for Mr. Earl. Second, Section 1983 permits First Amendment retaliation claims, and state prisons outnumber federal prisons by 7-1. Yet, there is no evidence provided that those claims have overwhelmed the court system. And Congress, yes, Your Honor.
So, hey, isn't the big difference that Congress has decided that there should be a 1983 remedy? Congress has not provided a Bivens type remedy legislatively. And isn't that a crucial distinction? As instructed by the Supreme Court, we're not supposed to be expanding in an area of extending remedies when Congress has not seen fit to do so. So really, why does it matter how many state claims, how many claims are brought under 1983?
Certainly, Your Honor. We do not argue that Bivens has a remedy for every single 1983 remedy. We merely point to the fact that this type of claim against low-level officers is available to many more people in state prisons, and yet there is no evidence that the claim has overwhelmed the system. There is necessarily a smaller pool of federal inmates who would be able to bring this claim. And that's only conceding, which the government does not, that retaliation happens regularly. And so these floodgates concerns are where we can use 1983 to see that there has been no massive increase in First Amendment retaliation litigation. This court would leave incredibly vulnerable people out to dry by affirming the district court's grant of summary judgment. People who are trying to use the BOP grievance process as it was meant to be used and who were unconstitutionally retaliated against for doing so. The right at issue here, which is the right to file grievances free from retaliation, safeguards all other rights and ensures that even meritorious and recognized Bivens claims, like Carlson claims, can see the courtroom and those can receive justice. For the foregoing reasons, this court should recognize a Bivens remedy and remand to the district court for further proceedings. Thank you.
All right, thank you, Ms. O'Hay. And the panel would like to thank both counsel for their assistance in making the hearing possible today. Everybody's had to go through some extra steps, and we appreciate your attention, and we've appreciated your argument as well. So thank you very much.
Thank you.
Thank you both.
Callahan, are you ready to proceed?
I am, Your Honor. Can you hear me and see me okay?
Yes, thank you.
Great. Thank you. Good afternoon, Your Honors. This is Sam Callahan.
Can I stop for just a second? We're still waiting for one more to come in. Hold on one second.
I apologize.
The United States Court of Appeals for the Fourth Circuit.
Thank you, Your Honors. This is Sam Callahan, again, on behalf of Mr. James Presley. Your Honors, this is a straightforward case of ineffective assistance of counsel. Mr. Presley's trial lawyer failed to seek suppression of highly inculpatory statements that officers elicited during an unmirandized custodial interrogation. This court in Gruninger said that there are two key questions for deciding whether that exact type of failure requires granting habeas relief. The first question is whether suppression likely would have been granted, and the answer here, as in Gruninger, is yes. Presley's interrogation inside a police vehicle in an empty church parking lot miles from his home was custodial under Miranda, It was custodial because an ordinary person in those circumstances would not have felt free to terminate the interrogation and leave. The second question is whether suppressing Mr. Presley's statements would have had a reasonable probability of changing the outcome of the trial. The answer again is yes. The government has not cited any appellate decision holding that a confession to a crime used in trial was not prejudicial, and this case is a very poor candidate to be the first. Just as in Gruninger, Mr. Presley's statements were devastating evidence that played a central, pervasive role in his trial. Because the undisputed record establishes both deficient performance and prejudice, I ask that the court reverse and to order that the judgment be entered for Mr. Presley. Starting with whether suppression likely would have been granted here, the government agrees that Mr. Presley was interrogated and that he was not Mirandized, so the only question for purposes of Miranda is whether he was in custody during the interrogation. The test for custody, of course, is whether a reasonable person would have felt that he or she was at liberty to terminate the interrogation and leave. Or as Miranda put it, custody if the suspect was deprived of his freedom of action in any significant way. And here, the key facts establishing that Mr. Presley was in custody under that test, I think are undisputed. These facts come from Lieutenant Christensen's trial testimony, which starts at 199 of the Joint Appendix, and also from Mr. Presley's affidavit submitted with his 2255 motion. That's at page 140 of the appendix. And in all material respects, Mr. Presley's affidavit hasn't been contested, despite the government's ample opportunity to do so at summary judgment.
And Mr. Callahan, let me ask you a question, and it goes directly to the issue of counsel's performance. Your position seems to suggest that irrespective of whether counsel believed that his client was telling the truth, he had to put the client on the stand. I mean, isn't that where this argument is leading? And doesn't that create a problem? I mean, if I represented a client and I didn't believe the client, I couldn't put that client on the stand. If the client had told me things that led me to believe conclusively, I mean, not just my own opinion, whether I believed him, but if I knew my client was not telling the truth, are you suggesting that I had to put him on the stand?
Well, Your Honor, there is nothing in the record that at all indicates that the basis for counsel failing to file the suppression motion here had to do anything with doubting the facts of what Mr. Presley relayed to him. The only signal in the record that I've been able to find of counsel's explanation for not filing this was that Presley, I think the quote is, made these statements on himself and that suppression therefore wouldn't do any good. That, of course, is just a misunderstanding of Miranda. Every unmirandized interrogation is going to produce statements on a suspect's self, so to speak. If the government or trial counsel's position was that there was some factual doubt as to what Mr. Presley had told counsel, summary judgment, of course, would be a great opportunity to have tested that explanation that's currently in the record, but the record's completely empty, and the government did not even bother arguing that this was some sort of strategic judgment or that counsel was doing anything besides misunderstanding Miranda when in declining to file suppression motion here. Yes, Your Honor.
Could counsel have considered this a problem of leaving his client open to an obstruction of justice enhancement? Put him on at the suppression hearing. It just seems to me there's so much going into the calculus that it isn't simply a matter of whether you could prove custody. There are a lot of things that a good lawyer has to weigh in making this determination.
Your Honor, I completely understand the concern. The concern, of course, is that lawyers are thinking about a lot of things in making decisions. But just two really important points on this. The first is that Gruninger dealt with a very similar situation where counsel came up with an explanation for not filing a motion to suppress. And counsel said, I thought the motion would have been baseless, and explained in an affidavit why that was the case. And this court reviewed the question under Miranda without deference to trial counsel's understanding of the case law and said, no, the motion wasn't baseless. It actually would have succeeded.
The reason for that is because it's an objective inquiry, not a subjective one, right? Is that the question is, could a reasonable, not this person, but could a reasonable attorney, and I imagine this happens all the time. In fact, I have some good reason to believe it does, where a defense lawyer listens to his counsel, listens to his client, and says either, as Judge Keenan first suggested, that it's not true, or more likely that putting them on the stand is going to have negative repercussions, both at an obstruction type charge at sentencing, but also potentially in cross-examination during trial, and weighs that against the unlikelihood that the court would believe the defendant over the two officers who testified to the contrary, and simply make a strategic decision not to file it. That seems to be an eminently reasonable decision given these circumstances. And we look at that objective inquiry to determine whether it is unreasonable, that so far below the realm that it is ineffective assistance. And I'm agreeing, I think, with Judge Keenan here. What I don't see from you is any explanation of that even if you are right, and just pause it for a minute, that you were right that he was in custody, or that you had some evidence that he was in custody, that you can't get over that strategic aspect.
Well, Your Honor, a few points there. The first is that I may be missing something. I'm having trouble understanding why Mr. Presley would necessarily need to be cross-examined at trial. If it's purely a suppression issue, this would have been resolved through a pretrial motion to suppress, where Presley would have potentially taken the stand. Although I would note that
the question is that if you testify in a pretrial hearing, it's not substantively used against you at trial. But if you testify inconsistently at trial, your prior testimony can be used to impeach you on cross-examination. So it's not substantive evidence, but it's impeachment evidence. Right. And if you were going to testify at trial, I'm just saying that it has negative repercussions, both potentially in trial for impeachment purposes and at sentencing for obstruction. And those strategic judgments could lead a very reasonable, in fact, maybe some of the very best lawyers to say, we need not throw a Hail Mary in the first quarter when we know it's not going to work and it has these negative repercussions that come behind it.
Right. And Your Honors, I understand the questions and the purpose of the questions, but I have to just insist, because this court now twice in Tice and in Gruninger has actually looked and said, we demand some sort of record evidence that there was a strategic judgment made here. And when there is no explanation that has anything to do with strategy, when it just is, I thought it wouldn't have done any good, I thought it was baseless, I didn't want to file it because I thought it was a loser, and it wasn't in fact a loser, this court has said that amounts to ineffective assistance of counsel. And so I think for the government had an ample opportunity here to come up with an explanation for counsel's failure to file a motion to suppress here. And what those cases stand for is that we can't now, sitting here without any support for the decision, hypothesize reasons that counsel may not have done it, especially.
Is your position that it's a subjective inquiry, so that we're only looking at whether that was the actual reason that the defense counsel, like in his heart of hearts, believed? I mean, we say all the time it's an objective inquiry, so why would it be a subjective inquiry here? That this was actually in his heart of hearts the reason that he did what he did.
Well, Your Honor, what I'm looking to in explaining this is Gruninger's explanation of the failure to file a motion to suppress as being a refined version of Strickland. And the reason it's refined is that this court has said now several times that the failure to file a motion with some substance is deficient performance. And so whether or not
it may have been in that case, but that's not, I'm sorry, Judge Keenan,
No,
that's
no.
not universally true, right? I'm confident, or at least let me ask you this. Do you think that is universally true? That the failure to file any motion that has some substance, no matter the negative implications that might result from doing so, is per se ineffectiveness? That's the argument you're making.
Well, Your Honor, I apologize. The next point I was going to make is that I think if counsel did have some actual strategic reason for not doing it, I think what those cases are best understood to say is that there is a presumption that you should try to seek exclusion of highly inculpatory evidence, particularly confessions. But if counsel, of course, says, no, there actually was a strategic purpose here, I think then it still is an objective inquiry. Could an objective lawyer, given the circumstances, choose not to file a motion to suppress? Yes, Judge Keenan.
Wasn't really what got the lawyer in Gruninger in trouble the fact that the lawyer was filing the suppression motion late on the first day of trial? Wasn't that a big part of the problem from the panel's or from our court's viewpoint? Not so much the counsel lacked a strategic decision regarding whether to file, but the fact that counsel was trying to do it clearly in violation of the rules.
Sure, Your Honor, the court did point out that that undercut that this was a strategic choice, but you'll note that the court then went on just in the next paragraph after talking about that late filing.
What page of Gruninger you're talking
sure,
about?
I'll pull it up right now. I apologize, Your Honor. Sorry for not having it handier. Okay, I'm looking at page 529 of the decision. And I'm looking at the paragraph that starts, regardless, any determination that he could not defend a suppression motion, and then it goes on to describe the circumstances that he failed to file the suppression motion, appears to rest less on informed legal judgment than on a legal misapprehension. And my understanding of that discussion is the court is saying it, regardless of the procedural mechanics of what counsel did here, the only evidence in the record of what counsel was thinking, and to go to the question of subjective versus objective, the court is saying the circumstances, of course, go to the objective inquiry. Could a reasonable lawyer in these circumstances decline to file? And we have to have some facts to know what those circumstances were. And here we just don't, there's nothing in the record suggesting any strategy to this decision. And in fact, there's affirmative signals that counsel just thought the motion would fail. And that is not strategy. Gruninger is very clear on that point. Yes.
Mr. Callahan,
Mr. Callahan.
I'm sorry, go ahead, Judge Traxler, please.
Mr. Callahan, this is Judge Traxler. I had, first of all, a question I don't know the answer to, but maybe I should. Did your client, in his paperwork that he submitted with his motion for summary judgment, state that he told his lawyer the things that are in his affidavit, all of the facts?
Your Honor, there's not a particular statement that he relayed every single fact, but he describes having explained the circumstances of the interrogation. Also, Mr. Presley then received the IRS Treasury interview memorandum in discovery, and again asked counsel to seek suppression of the statements. The memo, of course, detailed all of the inculpatory statements made and had some information about the location of the interviews. So I don't think there's any dispute that counsel.
No, but can we presume he told these things to his lawyer?
Your Honor, I will.
Is there a factual basis? Is there a factual basis for the district court to determine that the allegations and statements he makes in his affidavit were told to his lawyer before trial or during trial?
Yes, Your Honor. I would point you to page 142 of the joint appendix. Mr. Presley, this is Mr.
I'm
Presley's
looking at it.
affidavit. Mr. Presley's affidavit, he says, I told Wentz about the encounter with the agents and the statement I gave without having counsel present. I think, and again, this affidavit has not been contradicted despite opportunity to do so. So I think the only fair reading of the record is that Mr. Presley informed counsel about the nature of this inquiry. And I should add that,
Okay.
again, I'm sorry, Your Honor.
No, I was going to say, let me go to my second question.
Yes.
Your client has come forward with an affidavit and statement that indicated they were believed that he would have a legitimate argument he was not in custody. And my colleagues have told you a whole lot of perfectly legitimate reasons why a defense attorney might elect not to file a motion to suppress. But have they come forward with any reason? It seems to me that once the plaintiff has met his burden of coming forward with evidence to show he's entitled to judgment, that the defendants have to say the defense lawyer has to say something, give some reason.
That's Your Honor, that is exactly my understanding based on this court's cases as well. And I think the failure to submit any information from counsel or any other evidence in response to the motion for summary judgment with a sworn affidavit here, I'm sorry, in response to the sworn affidavit with his 2255 motion, I think indicates that there really is nothing on the other side here, not only when it comes to custody, but also to this point about this being a strategic judgment. I see that I've exceeded my time. I apologize.
Judge,
yes.
Can I beg the court's indulgence to ask one more question while you're here, and we'll give you time on rebuttal, I'm sure. So why is that? So Judge Traxler posits that the defense lawyer has to say something. If it's an objective inquiry, and maybe it's not, tell me if I'm wrong, but if it's an objective inquiry of what a reasonable lawyer would do, why does it matter what the defense lawyer would say? I mean, if he got up and said, it was Tuesday, it doesn't matter, right? The point is that it's an objective inquiry, right? And so his subjective belief, even if it was based on a mistake, if an objectively reasonable attorney would have done the same thing, isn't that the inquiry? And so what the defense lawyer has to say, while it might be interesting, is not necessary. So
this might be helpful on the sort of subjective versus objective point. I think the confusion might be that, my confusion at least, there has to be some set of facts from which you make the objective judgment. Was this a reasonable decision by trial counsel? The only facts in the record right now indicate that this was not a reasonable decision by trial counsel, because there's no facts suggesting that there was any strategic reason not to seek suppression of this. Highly inculpatory statement. It's a confession. So you have to take those facts and say, would an objective trial lawyer in those circumstances refuse to seek suppression? That's where I think Tyson Gruninger say, absent some explanation, no, it is not a strategic judgment in the sense meant by Strickland. It is unreasonable to fail to seek suppression.
Okay, Mr. Callahan?
Yes, Your Honor.
I'd like to follow up too on the issue of prejudice and ask you, and you can spend your time on rebuttal dealing with that too, but we've got a situation here. How do we find a reasonable probability of a different result? I agree with you that confessions are very damning, but here we have a situation of a major drug dealer, the evidence. We have cooperating witnesses. We have testimony from the IRS agent, Beers, about the defendant's lack of legitimate income. He wasn't filing his tax returns. He was dealing a huge amount of cocaine. Witnesses testified involving financial crimes, related financial crimes. So this wasn't a garden variety drug case, if there is such a thing. This was a really much more complex case. And so how do we find a reasonable probability of a different result when there was really overwhelming evidence regarding his participation in this sale of drugs and really very, very deep involvement in the criminal world of drug distribution?
Sure, Your Honor. And if I may start answering now, and I could return to this on rebuttal. So you noted at the beginning of your question that confessions are damning generally, but I think what's important here is that the confession was really damning in this individual case, and the government clearly thought so because it used the confession as its absolute central evidence. It put on Lieutenant Christensen early in the case. It was their marquee witness. He walked through the statements in scrupulous detail for dozens of pages of the trial transcript, came back to the statements in closing arguments. It began with them. It cited them as the primary evidence of guilt, especially on count 1, which was the overarching charge and the only charge that enabled Mr. Presley to get a life sentence in this case. It told the jury that it could just rely on Presley's statements to find guilt. In other words, like, that was it, you're done, I think was the quote. And then in the very last lines of the rebuttal before the court charged the jury, the government told the jury, quote, Presley admitted it. He admitted he bought the Suburban with drug proceeds. He admitted he was a drug dealer. That's a fact. That was the last thing the jury heard. And we cite several cases, and particularly at page 24 of our reply brief, showing that courts really treat the government's treatment of its own evidence as highly corroborative of prejudice, because prejudice is about what the jury heard, not just whether there was other evidence that could have potentially supported a conviction. And just one additional note here beyond the government's own reliance. You'll notice that count 1 required the government to prove trafficking of powder cocaine. And of course, without Presley's statements, the only other evidence supporting that activity came from cooperating witnesses who there was doubt as to their credibility exposed on cross-examination, and a strong signal that the jury doubted that testimony because they also testified against Linda Dawson, who was of course acquitted on all counts. So I think that there are very strong signals, far stronger even than cases where this court has found prejudice, like in Gruninger, where there was a victim who testified at trial as to each and every one of the sexual misdeeds of the defendant in that case, and yet the court found prejudice because the confession was so damning. I see that I'm well over time. I apologize if I may.
No, we asked you the questions.
Well, I appreciate you giving me time to respond.
We'll wait to hear again from you on rebuttal.
Thank you very much, Your Honor.
Okay. We'll next hear from Mr. Ron Gojaj. I practiced this ahead of time. I apologize. Mr. Rangarajan.
Good afternoon, Your Honors. Banu Rangarajan on behalf of the United States.
Thank you.
Your Honors, the government is confident with the outcome of the proceedings in this case, and the court can be too. In our brief, we highlight some of the trial record, but frankly, we could have done a better job for the court on the prejudice prong. And so I'd like to take a moment to highlight the trial record, which demonstrates that even if a motion had been filed and defendant's statement suppressed, there was no reasonable probability that the jury verdict would have been different. The defendant's confession was merely icing on a mountain of evidence. During this trial, which is at docket entries 145 to 152, it is a 1,500-page trial transcript. The government presented evidence on 5 controlled buys exceeding a quantity of 386 grams of crack cocaine. The testimony in connection with those controlled buys included the 2 cooperators, Smith and Ripley, a co-conspirator, David Williams. There was audio recordings, video recordings, there was GPS tracking device, there's photographs. In addition to those 5 controlled buys, the government presented evidence through 5 co-conspirators, Williams, Taylor, Brown, Ernest McNeil, and Lawrence McNeil. Brown himself testified that the defendant and him purchased together over 100 kilos of powder cocaine. Credibility determinations rest with the jury. The jury found these witnesses credible based on the special verdict form and the quantities they attributed to the defendant. In addition, the government had the defendant's own statements. During the course of Brown's testimony, he authenticated a September 2011 audio recording where he was trying to set up a consensually monitored purchase with the defendant. That audio recording with the defendant's own voice was played to the jury. They heard the defendant in connection with a drug trafficking offense. In addition, the government presented the testimony of an inmate, Albury, who was in pretrial custody with the defendant. The defendant admitted to Albury that he had been dealing drugs since 1990. in ounce to half kilo amounts. The defendant had told Albury about the supplier and that his supplier had turned on him. That supplier was Mr. Taylor, who testified at trial. And the defendant admitted to Albury that there was video and audio surveillance of his controlled purchases. You also had testimony from Taylor, where the defendant, the day before Taylor testified, had threatened to, I quote, whip his ass because Taylor was testifying against the defendant. You also have Williams, who testified the defendant admitted to dealing with Smith and Ripley, the two cooperating witnesses who set up the controlled purchases. That is just on the drug counts. The money laundering evidence was significant as well. And there was testimony from car dealerships, banks, the IRS agent, financial individuals. There was his tax return information. The defendant's residences, cars, and businesses were linked through by all of the testimony to the drug dealing and corroborated the testimony of Agent Beers, who had done the analysis of the financial records. It is against all of the weight of that evidence, his confessions came in. But I submit, the government submits to...
Excuse me, Ms. Rangarajan. How do you respond to Mr. Callahan's point, though, that the government kept bringing up the fact that he confessed? I mean, this was a big part of the government's argument. So how do we then, and I agree with you, there was a ton of other evidence in the case, but the government elected to place heavy emphasis on his statement. So how do we then decide that this wouldn't have affected the result?
During the trial, the government highlighted the defendant's confessions in two places, primarily. In Christian's testimony up front, during the course of his testimony. But in closing, the closing was over, I guess the first part of closing was over 30 pages, from pages 261 to 292. And the statement was referenced for maybe 3 pages, 265 to 66 and 275 are the joint appendix sites. And then in the second part of closing, which covered 13 pages, JA 323 to 336, it's referenced on pages 325 to 326, and then in a paragraph on 336. So yes, the government references it, but the government referenced it in the context of all of the other overwhelming evidence. So the government would submit that the trial record in this case supports the finding that there's absolutely no prejudice from the admission of these statements whatsoever. However, I would also like to turn and spend time on the performance prong of Strickland. And
can I ask you to help me understand what the first question is? So I maybe I'm wrong, but I think about this as 3 parts. First is about the likelihood of the motion being granted. Second, I think about the tactical decision making or lack thereof. And then third is prejudice. But on the first part, when we're talking about, as I think we've said in Gruninger and other places, that we look at the likelihood that the motion would be granted, or whether it was likely the motion would be granted. And my question is, how do we do that in light of the divergence between the plaintiff's allegations and the police officer's recitation of what happened? Are we asking the question of whether if the now plaintiff, but if the defendant, the criminal defendant's testimony was fully believed, would the motion be granted? Or, which would be one option, or are we asking, in light of the totality of the evidence, is it likely that the motion would be granted, which calls us to weigh the officers and the criminal defendant and make a estimation as to whether it was likely the motion would be granted? What are we doing here? What's the frame that I ought to have?
I think Strickland counsels the court to look at what the defense counsel knew at the time he was making the decision. So in 2012 to 2014 range before the trial. And I think if you look at the entire record and overlay that with what the defense counsel knew in 2012, 2014, it reflects an objective decision by that counsel not to file a non-meritorious motion. And if I could step back and explain to the court my basis. So the first time in the record that the government or anyone sees these claims of coercion in detail are the 2017 2255 motion by the defendant and his arguments therein. We need to step back to 2012. The interview took place August 23rd, 2012. The defendant is indicted 6 days later on August 29th, 2012. In his attachments to his own 2255, he submits a series of letters that he purportedly sent to his defense counsel back in the time frame 2012, 2013. In those letters, one example is JA 45. The defendant sends a letter to defense counsel talking about witnesses at trial. There's no mention of this coercion or this custodial interrogation. He has another JA 161. He attaches an affidavit from his brother, which is dated that reflects a January 9th, 2013 conversation with defense counsel. And that says, the defense counsel responds, James made the statement on himself and did not think it would do, the suppression motion would not do any good. There's JA 57. A defendant sends a letter to defense counsel on February 10th, 2013. He says, I feel it would be in my best interest for you to file a suppression hearing. I feel that it is only fair to me to know exactly what other evidence the government have other than what is in the motion. Yes, he asked for a suppression. He asked for a suppression hearing in the letter, but he doesn't again make any reference to coercion, threats, forced testimony, custodial situation. JA 56, another letter in March of 2013, there is no mention of the suppression issues. And this is consistent with the rest of the record, and that this was a voluntary statement to law enforcement in an effort to cooperate. And the reason we know that.
What do you do with JA 142, where he says, and I get this is after the fact, right? But he says, in 2012, I told Wentz about the encounter with the agents and the statement I gave, even though I had asked to have my attorney present. So he's at least alleging, he's making that allegation. He's not saying all the rest of this stuff, all the stuff about coercion. I get your point on that. None of that comes up till late. But at least he's made the allegation here that he claimed he asked for an attorney, and they, at least implicit, is that they refused to give it to him.
And that would pivot to basically a strategic decision that you didn't want to go through a suppression motion and a hearing where you would have to put your client on the stand in order to testify. And that's an objective choice by a defense counsel. Makes absolute sense. You don't want to risk perjury. You don't want to risk obstruction of justice. That makes perfect sense as a defense lawyer. But the reason there are
I need to ask you a question.
Yes, sir.
This is Judge Tractor. I need to ask you a question. It sounds to me like you're asking us to decide as a matter of law that this Mr. Horner is not believable. Am I right about that?
What I'm asking the court to determine is, what did the defense counsel know at the time that he made the decision not to file the motion to suppress? And the government's position is that the defendant did not share these facts that he's now presenting in 2017 to his trial counsel in 2012. And there are other places in the record that supports this.
And what is your basis for saying that?
If you look at both the, so you have the arraignment, Your Honor, where the defendant is specifically asked, is there any defendant who's not fully and completely satisfied with his attorney's services? The defendant makes no complaint, and that takes place on July 14th, 2014. During the course of the trial, the testimony unfolds consistently with the memorandum from the interview by Christensen and Beers. The defendant is present.
So wait a minute, let me interrupt you a sec. So if a defendant tells a judge he's satisfied with his counsel, he's foreclosed from ever bringing an ineffective assistance of counsel claim?
No, but he was given the opportunity to raise it with the judge, and he didn't. And at the
so you're saying based on the evidence in the record, we should find as a matter of law he's not believable.
Yes, Your Honor. That the 2017 information was not provided to defense counsel in 2012. And again, there are other places in the record that support this. If I could have a moment, I'll run through them quickly for the court.
Okay, but before you do, how can we make that conclusion as a matter of law at the summary judgment stage? I mean, don't we have to construe the facts in Mr. Presley's favor?
Yes, Your Honor, and I recognize that you're not, the court is not supposed to be making credibility determinations at a summary judgment, on a summary judgment motion. I agree with that. But what the court needs to do is it has to look at the defense counsel's thought process in 2012 and whether what that counsel did in 2012 up until trial, 2014, was reasonable in light of the information that counsel had. And I'm submitting to the court that that counsel did not have these details in the 2017, because if you look at how cross-examination unfolded at trial of Beers and Christensen, it only focuses on two people being there. The defendant was present. He was conferring with counsel. He was engaged in his defense. You move forward from trial to the motion to withdraw by defense counsel. The motion to withdraw makes no mention of defendant's complaint that he didn't file a suppression motion. You move forward to the sentencing memorandum. He's given new counsel. New counsel steps in. In the sentencing memorandum, they challenge the court's reliance on the defendant's statement, not because it was the subject of a Miranda violation. They argue that it was unreliable. They do the same thing at the sentencing hearing. The defendant is present, and there is no argument ever presented to the district court that it was in violation of his Miranda. It was all a question of whether it was reliable based in the context of the other evidence presented. And so if you're looking at what based on that entire record, it is reasonable. The decision by the defense counsel in 2012 to 2014 not to file a suppression motion was objectively reasonable. And
okay,
that is what.
Let me follow up with one more question. Why wouldn't the most practical thing to do here would be to remand it for an evidentiary hearing and just ask counsel, why didn't you file it? Wouldn't that really resolve things pretty quickly here?
That would with respect to the performance prong, but the court has the ability to affirm on the prejudice. And I think that the prejudice prong resolves it for the court, because the court can resolve.
Exactly, but when you're resolving something on the prejudice prong and you're doing it on the credibility of the defendant or lack thereof, as you seem to be doing, at least in part, it seems to me that, you know, maybe what we need to do is just see if the lawyer was even thinking about it at the time. You know, trying to figure out what actually happened these many years ago.
And if the court has any concerns, that is absolutely the correct course to go, is to remand for an evidentiary hearing on the issue regarding performance. But the court, again, the prejudice prong does not go to the defendant's credibility. There is no credibility determination necessary there. So the court can affirm the dismissal based on that other piece of the Strickland test. So given, and the other thing that the court may wish to consider is also the context of this confession. It was that would leave the attorney to reasonably conclude that it was a voluntary statement. According to the agents, they went to his house, asked him to follow them. He follows them 10 miles out of town, gets into a car, makes a statement. When the agents approached the defendant in August of 2012, they had already had the 5 controlled buys. They already had the audio tape from Antoine Brown. They did not need any additional evidence to arrest the defendant. They could have arrested him. What they wanted, and what is evident, is that they wanted his cooperation against Taylor. So they invited him to go, 10 miles out of town to Dunn, outside the county lines to a church. And the reason they asked him to go 10 miles out of town was so no one would see him, because that would undermine cooperation. So the defendant agrees to go with him. He goes with them, he gives a statement, and then later changes his mind and doesn't want to cooperate. He goes to trial, he loses, and now he's having remorse. And that scenario is something that the trial attorney also had before him, that I've got this law enforcement statement, he went with them voluntarily, there is evidence that he voluntarily spoke with them. That would have been part of the information defense counsel would have considered in deciding whether or not to file a motion. And all of these things play into his objective, reasonable decision-making process not to file the motion. So unless the courts have any additional questions for me, I would just say to the court, given the profound importance of the finality of judgments and the highly deferential review of trial counsel's decision, combined with the jury verdict, which is supported by substantial evidence separate and apart from defendant's statement to law enforcement, the government would ask the court to affirm the district court's decision.
All right, thank you, Mr. Mangarajan. And we'll hear from Mr. Callahan on rebuttal.
Yes, thank you, Your Honor. There are quite a few points here, so I'll try to be brief with each. This first point about that has come up truly for the first time, not just in this appeal, but at oral argument. This is the first time I'm hearing this argument that counsel may not have had all the facts to make a suppression motion. There's no basis in the record for this concept. The only thing in the record indicates that Presley told his lawyer about this encounter and asked him to seek suppression. And then a Treasury memorandum showed up in discovery and he asked counsel again to seek suppression. I really don't understand the basis for doubting that counsel had the facts necessary. And Your Honors, the government made an argument in its motion to dismiss Mr. Presley's motion that this was a strategic judgment that the court should defer to. It then lost the motion to dismiss, and then at summary judgment, it did not even raise this argument at all. I just think to do this now, it's a little bit late in the game. But I do want to possibly simplify things, because even taking on its own terms the argument that counsel was making a strategic decision because he may have doubted Presley's account of the facts, our position is that if you take Lieutenant Christensen's description of what happened here, this was a custodial interrogation. I understand that there are some divergences between the sort of language that Mr. Presley describes and how Lieutenant Christensen describes the encounter, but our position has consistently been that the custodial nature of this interrogation is self-evident from how Lieutenant Christensen describes it, I should say.
Help me understand that. I mean, I took you earlier to say that his affidavit, including, the claims that he was followed by a bunch of officers and that there were, whatever it was, 20 people around him with guns drawn in the church parking lot, that we had to accept all those things as if they were true. But now you're seeming to say, instead, we can just rely on the officer. Help me understand the...
Your Honor, yeah, let me be very clear. I think it is black letter law that you have to accept any uncontradicted fact in Mr. Presley's affidavit. It is uncontradicted with any evidence of summary judgment. I'm saying that to the extent you are inclined to defer to this newfound strategy argument about counsel deciding not to file a suppression motion because he doubted Mr. Presley's account, he thought he was potentially committing perjury, I'm saying put aside Mr. Presley's facts and look at what Lieutenant Christensen said. This was a custodial interrogation. They approached him by surprise outside of his home, told him to get in his car, follow them to an empty church parking lot 10 miles away.
Can I ask maybe the follow-up to that? If I disagreed with you, and so if I thought that the officer's rendition was correct, that there was no custody, but under your client's rendition, the 20 officers followed, guns drawn, etc., threats and the like, that it might be custody. What am I left to do at this point, right? I mean, I understand what a trial judge would have done, but at this point in habeas, how am I supposed to resolve that?
Your Honor, I think the proper course in that situation would be, as 2255B requires, to order that an evidentiary hearing be held, because there would be a material dispute of fact about whether suppression likely would have been granted, which goes both to deficient performance and prejudice.
Hey, Mr. Callahan, though, how do we find a mountain of evidence that we've got here? I mean, there's just a ton of evidence of this defendant's involvement in the drug trade. How do we find that there's a reasonable probability of a different result? Are you hitching your argument mainly to different results as to punishment as opposed to different result as to overall guilt?
Yeah, so Your Honor, I think at an absolute minimum, there is clear prejudice as to count one of this crime, count one of the multiple counts against him, which charged both crack and powder cocaine. The laundry list approach to prejudice here, just sort of listing off bits of evidence, it sort of belies the fact that there were multiple separate counts of conviction that rested on different evidence. And in fact, the fact that the government views this as one big ball of wax is actually, I think, supportive of prejudice, because that's exactly how they presented this case. If you read closing arguments, the confession is the centerpiece. It's Mr. Presley admitted to being guilty as to every bit of conduct we charge. Let me also list a few bits of evidence as to each individual count to support that, and then coming back to the confession at the end to hammer it home. I think that supports that there was prejudice as to each and every count of conviction. It does not undercut it in any way. And Your Honors, just to reiterate the point, courts really do look very closely at how the government uses evidence when it comes to prejudice. It is not a sufficiency of the evidence inquiry. You need not find that the outcome is more likely than not different. I think, as I mentioned before, the undisputed record establishes that Presley should be awarded judgment. But if this court has any doubt, an evidentiary hearing is the absolute minimum required under 2255B. And we would ask that the court reverse. Thank you.
All right. Thank you very much. I'd like to thank both counsel, Mr. Callahan, Ms. Van Garage. Both done an excellent job here today. And the court especially appreciates your help in assisting us in making this technology work and allowing us to conduct our business. So thank you very much. And we appreciate your help and participation in good argument. Good afternoon.
Thank you, Your Honor.
Thank you.
Would you proceed, please?
Thank you, Your Honor, and may it please the court. My name is Sean Mirsky, and I'm here on behalf of Mr. Obando. The question in this case is whether the phrase "any civil action" in the Equal Access to Justice Act encompasses habeas petitions challenging the lawfulness of a civil detention. Every court of appeals to consider the question directly has held that the answer is yes. The question today is whether this court will side with its sister circuits or instead hold that a civil proceeding challenging civil detention in conjunction with civil immigration proceedings does not constitute a civil action. I'd like to start, if I may, with the government's argument that O'Brien controls the outcome in this case. That's incorrect, and I think the Second Circuit's decision in Vacchio helps explain why. The Second Circuit in Vacchio was positioned identically to the way that this court is positioned. It was considering a prior precedent, Boudin, which used at times very expansive language about whether any civil action within the meaning of EJA applied to habeas proceedings. But the Second Circuit rightly realized that its precedent was solely limited to what we refer to as criminal habeas petitions, that is to say, habeas petitions challenging some aspect of underlying criminal detention. And the Second Circuit, looking at the question of non-criminal habeas detention, and specifically an immigration habeas case like the one here, concluded that it was a materially different instance and not controlled by the prior decision. And the same thing is true here, in fact, on steroids. O'Brien, by its very terms, expressly distinguished immigration habeas cases. It said that they were, and I quote, readily distinguishable. And so it's hard for me to understand why the government believes that in this particular case, O'Brien nevertheless controls. And we don't know what the government makes of that language in O'Brien because nowhere in their brief do they actually address it. Instead, they suggest that the reasoning of O'Brien somehow controls the outcome in this case. But the opposite is true. If you look at O'Brien's reasoning, it makes clear that the reason it held that a criminal habeas petition does not unambiguously qualify as a civil action is because of the nature of the underlying detention, that is, the criminal detention.
Counsel, can I stop you for a second? I understand the argument, and we can debate about whether the discussion of those two cases is really a limitation on the holding, but I want to ask the sort of like maybe more fundamental question, which I think is that if you accept O'Brien, what I'm having trouble with is understanding how we can conclude that civil action, whether it includes habeas or not, turns on the underlying facts of the habeas action instead of the nature of the habeas action. Here, I mean, all habeas actions by their natures are, attacks on the legality of detention. And the line you're trying to draw, as I understand it, is the underlying facts. Is the detention civil or is the detention criminal? But that's not the nature of the action. The nature of the action is the attack on the legality of a detention of one type or the other. And what I'm having trouble getting my head around is how a statute's same use of the word civil action somehow it means something different depending on what the underlying facts are, as opposed to the nature of the action itself. Does that make sense? And can you help me understand how it is that the same language means something different when the facts underlying the action are different?
Sure, and I think it's worth noting that, there's a strong argument in favor of the idea that O'Brien in some sense was wrongly decided, and that—
Totally get that, but I can't do anything about that. So accept O'Brien is correct for my question.
Absolutely, and I think the way to understand O'Brien is to basically say that that by their nature, habeas proceedings are civil. And what happened in O'Brien is that the habeas case concerned an underlying criminal detention, and O'Brien concluded that that on its own was enough to turn it into something that it called a hybrid action. That logic applied here does not in any way lead to the same outcome as O'Brien, because of course the underlying proceeding—
I understand that, but my point is a more fundamental one, right? The words civil action means something, right? And what you're trying to tell us, in order to distinguish O'Brien, I understand why you're trying to do it, but you're trying to tell us that the word civil action means something different depending on the underlying facts, as opposed to the type of action. And that's the challenge. I understand the logic and reasoning that you want to talk about in O'Brien, but the fundamental problem I've got is you got the same words, civil action, and where I can't figure out is how that should be different, whatever it means, how it can be different in a scenario where the type of action, that is habeas, is the same, but the facts in one case are criminal and the facts in another case are civil. That's I understand the reasoning of O'Brien. How can I read those words to mean something different based on the underlying facts?
So 2 points on that, Your Honor. The first is that I think habeas proceedings, especially the way O'Brien understood them, are in a lot of ways seen as an extension of the underlying proceedings. And so in the context of a criminal habeas action, the vehicle, of course, is still habeas, but it is in some sense seen as an extension of the underlying criminal proceedings, and therefore doesn't constitute a civil action. In contrast, of course, here, the vehicle is still the same vehicle, but the underlying proceedings that it's acting as an extension of are civil proceedings. And that much, I think, is undisputed. The second point that I'd make is that the line that you're suggesting is the same line that not only O'Brien itself, I think, has suggested, but that is central to the reasoning of the Second Circuit and the Ninth Circuit, and has been adopted in practice by practically every single court of appeals to look at the question. And so for this court to kind of go down the road that you're suggesting would require opening a clear circuit split with both the Second and Ninth Circuits, and to deviate not only from other courts of appeals practice, but even from the practice of the Fourth Circuit itself. And and I should also mention on that front that the Supreme Court has itself often has allowed attorneys' fees in the context of non-criminal habeas petitions. And I think part of the reason that the line makes sense is because the Supreme Court has been at great pains to stress over and over and over again that habeas is a civil action. It is, as a vehicle, completely civil in nature. And so I understand your concern, but I think the answer is that O'Brien has to be understood as a narrow exception in some sense to that overall rule. The Supreme Court has never once held that habeas is anything but a civil action. And so the O'Brien approach of kind of seeing it as a hybrid vehicle has to be understood only in the context of the underlying criminal detention. It's also worth noting, Your Honor, that the concern about sort of looking past the vehicle to the underlying facts is much more of a problem for the government than it is for Mr. Obando. And the reason why that's the case is because the government in its brief proposes a test that seems to rely on whether the underlying proceedings have some what they call criminal aspects. Our line is relatively straightforward.
That's their secondary argument. Their first argument, I understand not to be that. They do make that point, and you make a big deal of that in the reply, but that's their secondary argument, right? Like, if you don't agree, then this. And so that's the straw man. I'm not sure that helps you on this point.
Sure, but then on this specific point, I mean, I think it's hard to understand how O'Brien could control here, at least as a matter of its holding, when it, by its terms, distinguishes habeas cases. And that I just
ask that one more question, and then I apologize, Judge Keenan. I'll try to be quiet, or at least I'll do my best. So I understand you take the two cases that O'Brien distinguishes and say that that's a limitation. But when I read O'Brien, in every instance, right, it says the holding as being a habeas proceeding without any limitation. In the very first sentence, that's what the question is about, right? And it gives an answer. In the last paragraph, it's about a habeas proceeding, not a specific type of habeas proceeding, not one with the facts are this way or that way. It gives a broad rule. It could have given a narrow rule. I understand that it could have, but it didn't. And when it chooses to adopt this, it's a little bit of a question of the scope of a holding question. How do I understand when they give a broad rule, and even if they could have adopted a narrow one, they didn't, right? The language that they use is a habeas proceeding, right? And not a habeas proceeding where the underlying facts are criminal in nature.
Sure, but 3 points on that, Your Honor. The first is I think that the approach this court should take is the same one that the Second Circuit took in Vacchio, where I think the case was even more compelling for the argument that you were making. Boudin, by its terms, didn't even distinguish immigration cases. It simply talked about habeas actions broadly. And we, of course, concede that the language in O'Brien is quite expansive. But I think the fact that O'Brien, at the end of its opinion, goes expressly out of its way to say that the rule in the Second and Ninth Circuit is different tells you everything you need to know about whether O'Brien can possibly control in a case like this one, which, as the government concedes, is like those other cases.
Okay, Mr. Mirsky, though, it seems to me that you're giving away some of the language of O'Brien that you could be relying on. Let me direct your attention to page 505, the middle of the first left-hand column in my printout, which says that to the extent that a habeas proceeding reviews a criminal punishment with the potential of overturning it, the habeas proceeding necessarily assumes cases criminal nature, and then went on to talk about why that was the case in O'Brien. And the court analogized the habeas proceeding with and its relationship to the underlying matter instance with a declaratory judgment, and said that to the extent that a declaratory judgment takes on aspects of the underlying case, the criminal aspect of this case is what's controlling. Now, I'm not quoting that last part. That's my paraphrase. It seems to me that you're, why isn't this helpful to your case, and why haven't you talked about it?
Well, we absolutely
something here.
We absolutely agree, Your Honor, that is helpful to my case. And in fact, that was going to be my second point to Judge Richardson. That particular quote can be multiplied several times across O'Brien. It's true that O'Brien talks about habeas proceedings generally, but when it starts actually getting into the reasoning over and over and over again, it makes clear that it's talking about criminal habeas proceedings. I mean, the word criminal or a derivation of it is used 24 times in O'Brien. Just above that quote, Your Honor, O'Brien talks about habeas proceedings being neither a wholly criminal nor a wholly civil action, but rather a hybrid action that is unique, a category unto itself. Of course, that entire reasoning doesn't apply to our case, where there is nothing criminal at all about it. And Judge Richardson, I think one of the key points here is that to the extent that the suggestion is that O'Brien's holding somehow binds this court, it would be awfully strange to come to that conclusion by having to first reject O'Brien's reason. I mean, O'Brien's reasoning, I think, as for the reasons Judge Keenan mentioned, and as we laid out in our brief, is very clear in pointing out that it is strictly talking about the fact that there are underlying criminal detention that makes the habeas vehicle into something less than or different than a civil action.
Oh. Okay, but I mean, the problem is that when he talks about the Sotelo, Aguayo, and Hill case, he says, yeah, those are distinguishable, but regardless, we disagree with them. I mean, that's the regardless, to the extent that, and you want to make a lot out of it to the extent that, but to the extent that there's a difference here, we reject it. And so, sorry, the screen's just moved. I thought we lost just track sort of, but it seems like to me, you're putting a lot on this idea when in fact, the ruling that the court adopts is a broad one, which is a habeas action, not limited to it. Agreed, it talks about different natures of actions in describing it. And it says, as Judge Keenan recognizes, that where there's criminal, it takes on some aspects of criminal, and then it goes on further in that same paragraph and says when it's civil, it has both. It also has some criminal civil aspect, right? And talking about the Tom decision. But at the end of the day, yes, that's true, but the holding is a habeas proceedings.
Respectfully, Your Honor, I'd like to push back on that last point and then make a specific point about the court's language about Sotelo, Akihei, and Hill. On your broad point, the court's holding is not, I think, necessarily what the exact words that the court used. I mean, Chief Justice Marshall's, famous point in Cohen's versus Virginia tells us that general expressions don't control in a case like this. And so that calling that the ruling or the holding, I think, would be a mistake, even if O'Brien hadn't expressly said that these cases are readily distinguishable. But turning to the line that you mentioned on page 508, as you know, we do think that that's dicta. I mean, it's expressly set up with, the phrase to the extent that. But I think there's actually a second and arguably more important point, which is that the court was saying that to the extent we have to choose between two one-size-fits-all rules, namely that either all habeas proceedings count as civil action or that none do, we would favor the latter. And whether or not that's right, that's not the decision before this court. The decision before this court is simply whether a non-criminal habeas action should be treated as anything other than the civil action that it indisputably is.
Hey, Mr. Mirsky, I think we've got to get to the question that I think is, and I am very sympathetic to your point of view, I'll tell you right out front, but the thing that makes your case a potential loser, at least from my point of view, and that I think you need to address is the issue of the waiver of sovereign immunity that we have to find in this case. How do we find that? It's got to be more than just all civil actions. How do we find that?
Absolutely, Your Honor. So essentially, there's two different ways to do this. The Supreme Court has clarified in recent years that the sovereign immunity canon, at least as it sort of applies to this case, is a rule of thumb that essentially acts as a tiebreaker when after the court has applied every other tool of statutory construction, some ambiguity still exists in the statute. And so in that respect, it's akin, I think, to the rule of lenity or something like that. And I want to be clear because there are really two different sovereign immunity canons, and one of them I think remains considerably stronger than the one that's at issue in this case. There is still a very strong kind of clear statement rule as to whether the government has waived its sovereign immunity in the first place. And we're not trying to dispute that the standard on that is any different or how that applies, because that's not relevant here. The EJA by its very terms waives the government's immunity, and I don't think anyone disputes that. The only issue in this case is how do we read the scope of the waiver? And as we suggest in our brief, since Richland in 2008 and follow-on cases from the Supreme Court, it's become very clear that.
Mr. Mercer, can I interrupt you just a sec? This is Judge Traxler. Doesn't the waiver of sovereign immunity have to be unequivocal?
Yes, Your
Honor.
Honor.
I didn't hear you use that term, but
well, yes, Your Honor, but only as to whether there is a waiver in the first place, not as to the scope of the waiver. And that's a pretty key distinction because in this case, we're only talking about the latter. And so you're right that the unequivocal rule does apply, but not to this case because there is a waiver and no one disputes that there is a waiver. And that's a I think, fairly key point to understanding why, in this particular case, the canon is only a statutory rule of construction in the same way as it was in Richland.
O'Brien doesn't read it that way. I mean, I understand you sort of look at that a little differently, but O'Brien, one might say, takes a robust view of the canon. And so, I mean, the problem I'm getting with is, if we're on a clean slate, you have an argument, but given O'Brien gives such weight to that in this very question, why am I supposed to ignore that and base it on what I gather you're saying is sort of an implication from the Supreme Court that is maybe not as strong as it once was?
Well, that's right, Your Honor. And it's worth noting that Richland and these follow-on cases post-dated O'Brien. So to the extent that O'Brien did apply a more robust version of the canon, I don't think there's any particular reason to think that this court is still bound by that, especially because that I don't think is in any way part of its core holding. But to Judge Keenan's earlier point, I mean, I think first that there is no ambiguity here in the phrase. And second, to the extent there is any ambiguity in the phrase alone, I think that ambiguity is amply resolved by the act's context, legislative history, and purpose. I see that I'm well over my time, but if I can briefly just make one point on that. The government, in the course of its brief, does not give a single indicia of congressional intent to suggest that as of 1966, when the phrase any civil action was first inserted into the aegis predecessor statute, that it meant anything other than a capacious reading that includes non-criminal habeas actions. And so given that, I just don't understand how this court, on the phrase alone, could even say that it was ambiguous when the government has put in essentially no argument as to why it would be. But again, even to the extent that there might be some sort of argument there, I think it would be resolved by the completely one-way effect of the act's context, legislative history, and purpose.
All right, thank you, Mr. Mirsky. You'll have some rebuttal time left as well. We'd like Mr. Robbins now.
Can everybody hear me okay? Yes? May it please the court. I'm Jonathan Robbins here on behalf of William Barr, the United States Attorney General. Good afternoon to everyone. In 2005, this court in O'Brien against Moore expressly held, quote, the aegis waiver of sovereign immunity to awards of attorney's fees does not extend to habeas corpus proceedings. The district judge in this case correctly applied that holding to this case because this petition for review arises from the petitioner's habeas corpus proceedings. Now, of course, this case turns largely on whether you agree with the district judge and find that O'Brien is controlling to the instant matter. And given that that is the case, I think it's worth pointing out exactly what the concept of stare decisis includes. Because the concept of stare decisis doesn't just simply mean that the court adheres to a prior holding of the court. The court is supposed to adhere to the mode of analysis that got the court to that decision. The court is supposed to adhere to the explications of law underpinning the decision. And when you understand stare decisis in that context, it becomes clear that the arguments that petitioner is making in this case simply cannot be reconciled with the reasoning and rationale of the court in O'Brien. So as Judge Richardson alluded to in his discussion with my colleague, the court has already held that the term civil action in this precise statute is ambiguous. So petitioner's arguments with respect to the notion that the statute isn't ambiguous are expressly foreclosed by precedent. He simply can't get away from the reasoning of the court from that decision.
Okay, now, well, Mr. Robbins, if I could ask you, yes. It seems to me that you could make a fair argument that the court in O'Brien reserved the issue of whether these immigration cases, habeas cases, are civil in nature, because at the bottom of 507, the court, when it deals with In re Hill, simply says O'Brien's circumstances are readily distinguishable from these immigration cases. So isn't a fair reading of that that O'Brien's just saying, we're not talking about immigration cases. That's not what we have in front of us.
Well, Your Honor, I would agree with you.
Why isn't it a fair reading that they left that for the next day when that is in front of the court?
Because the court didn't stop there, Your Honor. I agree with you that it is true that the court initially distinguished the cases, and I'll get to that in a second because that distinguishing characteristic actually supports the government's argument. But then it also went on to say that it found the cases unpersuasive. In fact, it cited, for example, to the Ninth Circuit's decision in Hill as an example of a case which exhibited, quote, spotty adherence to the waiver of sovereign immunity. So I think it's clear from the decision that the O'Brien court disapproved of the reasoning from those cases. But getting to Your Honor's point about distinguishing the cases, I would ask the court to take a very close look at how the court distinguished those cases. Because what the court did is it distinguished the substance of the remedy being sought in those cases. In the Hill case, for example, in the Ninth Circuit, the individual in that case wasn't using habeas as a challenge to custody. They were using habeas as a challenge to a larger immigration policy. It's a very dated case, but the applicant, the non-citizen in that case, was attempting to challenge the government's exclusion policy for somebody who had made an admission of homosexuality at the border. A very old case, but it didn't involve custody. And the court in O'Brien distinguished that case by pointing out O'Brien's case is different. His case does challenge custody. And that's exactly what we have here because the petitioner in this case is challenging custody. So to the extent that the court distinguished the cases at all, one, it went on to also disapprove of the cases, but two, that distinguishing characteristic supports the government's argument here because here we have the similar challenge to the legality of detention that O'Brien was making. So I don't think,
Counsel,
yes.
Counsel, what do we do with the footnote in Schlanger where the Supreme Court says in Schlanger, the Supreme Court's decision where they describe what nationwide service of process is for a civil action. And the court there says, in essence, a civil action does not include a habeas action. And in that habeas action was a civil habeas action. It was involving a soldier, if my recollection holds, but it was not a criminal action. And the court there says that in that context, a civil action did not include that type of civil habeas corpus action. And so to the extent that we thought O'Brien left that door open, should we read Schlanger as closing that door and telling us at a bare minimum that a civil action is ambiguous and that at least in that statute that it did not include a civil habeas corpus action?
We would certainly argue that, Your Honor. We've cited to a number of different Supreme Court decisions that have refused to treat the statutory term civil action as encompassing habeas. Schlanger is certainly one of them. But I would dispute the notion that O'Brien leaves the question open. One of the things to remember here is that when you're talking about habeas actions, yes, there are some habeas actions that will lean more civil, and there are some habeas actions that will lean more criminal. That's the nature of the hybrid action. But what O'Brien said is that when you look at the entire scope of habeas actions, too many of them function as a hybrid type of claim to conclude that Congress intended for each to be applicable to them. So it's not that you could look at one specific type of habeas case and say, well, that one really leans civil. You're supposed to look at all of the habeas actions to determine, do they differ in function significantly enough such that we can't evince an unequivocal intent from Congress that EJA was intended to apply to them. So Schlanger is one example of that, sure, but I think there's a host of examples. And particularly, O'Brien distinguished the cases in Hill and Sotelo-Akije. One of the things that's interesting about those cases is they're not cases you can bring anymore today. Those cases, as I mentioned before, were attacks on larger policy issues. But you can't bring those type of claims today. Congress repealed that in, I think it was EDPA. Those types of claims can't be brought in habeas actions anymore. The only type of habeas actions you can bring in immigration proceedings now are challenges to custody. That makes them virtually identical to the criminal type of habeas cases that we're dealing with here. So that's just another reason that I think that we simply can't evince the required intent from Congress that they would have wanted EJA to apply in habeas actions. They've specifically removed some of the larger policy questions from habeas. And so petitioner's argument that the purpose of EJA is to incentivize this type of challenge to larger policy questions I think falls by the wayside, given that you can't bring those types of claims anymore in the habeas context. I do want to address petitioner's argument about the Vacchio case in the Second Circuit, because certainly I think we would all agree that's the decision that most supports its position. But I would respectfully reject the notion that this court is in the same position as the Vacchio court. The Second Circuit in the Vacchio court was not in the same position as this case was in O'Brien, because the court in Booten, in its prior case Booten, where it found that EJA was not applicable in the criminal habeas context, didn't address anything about immigration. In fact, the Vacchio court was very, very careful to say, we didn't mention anything about immigration-related habeas in that context. That's not the case from this court in O'Brien. This court in O'Brien was well aware that other cases had refused to apply or had refused to extend that holding to the immigration context. And yet, as Your Honor noted, it still used that broad language saying a habeas corpus proceeding. The court could very well have done what the other courts did and said, we're going to only decide the criminal context here today, and we're not going to address the civil context or the immigration context. It didn't do that. It was aware that other circuits had made this distinction and refused to make the same distinction. That is why the district judge in this case relied on that case as controlling, because he specifically noted the district court, this court in O'Brien did not make the same distinction that it was aware that other courts had made in those other cases. There's, of course, our secondary argument that these cases are hybrid. We've cited to a lot of law, again, a lot of Supreme Court law and a lot of circuit courts law, which have recognized these habeas claims as hybrid actions. And we're talking today about immigration habeas versus criminal habeas, but that's really an artificial distinction that doesn't find much support. The Supreme Court has said that the statute controlling both immigration-related habeas claims and criminal habeas claims is the same statute. They both have the same legal standards. They both have the same legal rule. They are the same proceedings. Petitioner is trying to make the argument that because it stems from somewhere else, that makes the nature of the proceeding itself different. And I certainly think that where a case stems from can influence the nature of habeas proceedings. I think it can contribute to it. But that doesn't change the fact that the proceedings themselves are the same. So just by way of illustration, the Supreme Court has held that the criminal standard of review is applicable in habeas claims. Well, that holds true whether it's a criminal habeas claim or an immigration habeas claim. So that's getting back to what the court said in O'Brien about the function of habeas claims. The way they function differ across the board, depending on what kind of situations you have. And so, yes, look, there are immigration cases that will certainly maybe lean more civil than certain criminal habeas claims. But the fact remains is that in these cases, the individual is challenging the legality of detention. That implicates far more than mere civil liability. That implicates somebody's freedom, their custody. And
well, how is this a hybrid civil criminal case? There's no underlying criminal detention.
There is. It was petitioner's criminal conduct that subjected him to the detention in this case. In fact,
right, the detention is not criminal. It just goes to the nature of his prior record. The issue is deportation and detention under our immigration laws. How is that even remotely criminal?
Right, but the mandatory detention, Congress has mandated detention for individuals who have been convicted of certain crimes. So the basis of detention, you're right, it may be administrative in nature, but it's based on criminal conduct. I think that at least turns in part on a hybrid analysis, especially because in the immigration context, if your honors are familiar at all, a lot of the ways we analyze the criminal statutes in those cases mirror what we do in the criminal context. If your honors are at all familiar with the modified categorical approach and the categorical approach and those analyses, it's the same in the immigration context.
Well, but it's the detention itself is a civil detention.
I agree, Your Honor.
Yeah,
I agree, Your Honor, but Congress has mandated that certain people with certain convictions be subject to mandatory detention. That is what was happening in this case. So it was based on underlying criminal conduct, which is the same as was in O'Brien. Yes.
Yeah, counsel, your colleague suggests that after the Richland case that we should look at the sovereign immunity canon differently, at least with respect to the scope of that. Certainly there's some commentators that have said that, but do you agree with that? Or do you take the position that Richland is just a case where the Supreme Court said that there wasn't ambiguity, and I think to the language is used, to the extent there's ambiguity, that stare decisis answered the question. That is what resolved the sovereign immunity canon, and not some sea change in the way that we think about the unequivocal waiver that's required. But where do you come out on that debate?
Well, we think Richland is certainly distinguishable for the basis which you just said, which is that the court did not find that the statute was ambiguous. But I would refer, Your Honor, specifically to specific language from the Supreme Court on the issue of waiver of sovereign immunity. Because Richland does not overturn this holding by the Supreme Court from the Lane case and citing from Nordic Village. Quote, a statute's legislative history cannot supply a waiver that does not appear clearly in any statutory text. The unequivocal expression of elimination of sovereign immunity that we insist upon is an expression in statutory text. That has not been overturned by the Supreme Court. And so Richland, yes, it was dealing with a statute that was not ambiguous. That is simply not what we're dealing with here, because the court has already held that the statute in question is ambiguous. And when it's ambiguous, the statute is supposed to be strictly construed in favor of the sovereign. And the key word there is strictly. That's why the Vacchio decision from the Second Circuit is really unpersuasive in my view, because the court recognizes that the sovereign immunity waiver applies in a footnote, and then it proceeds to look at the legislative history. Well, the Supreme Court expressly said that we're not supposed to do that. We're not supposed to use the legislative history to replace what should be unequivocal from the statutory text. And that's where petitioner's argument really falters, because what he's asking you to do is to, you've already held that the statute is ambiguous with respect to, at any minimum, criminal habeas. And now you're supposed to say that the same statute evinces an unequivocal intent that Congress intended to have this applied to immunity-related proceedings. Well, how can that be? Because the reasoning of O'Brien was that they examined congressional intent and said, we can't discern congressional intent with respect to habeas. Well, if the court had, you would think the court would have said something to the effect of, well, Congress had said something to immigration-related matters, but it hasn't said anything to criminal immigration matters. It didn't do that. It just said that there was no intent at all.
Mr. Robbins, it seems to me, though, that your argument is looking at it through kind of glasses of bifurcation. I mean, isn't really the question here for us to look at the statutory text and determine whether Congress unambiguously waived immunity as to purely civil cases? In other words, it seems like your entire argument is presupposing that there are is relying entirely on distinctions in types of habeas cases. And why don't we just look at whether this purely civil case, there's nothing, and I know you're saying you got to look at this prior criminal record, but people aren't treated differently based on their, I mean, in terms of detention. Once they're detained, they're civilly detained under the immigration laws. They're not criminally detained. And so why don't we determine whether Congress was unambiguously waiving sovereign immunity in terms of purely civil cases, that is, where the underlying detention is immigration rather than criminal?
Well, I think you do look at the statutory text to determine whether there's an unambiguous intent of Congress to do that. But the problem is that the court has already held that this term is ambiguous with respect to habeas proceedings. And habeas proceedings, whether they stem from civil proceedings or criminal proceedings, are unique unto themselves. They're the same proceedings in criminal and immigration matters. And that's the point we're making. So I would quibble a little bit respectfully, Your Honor, with respect to the notion that these habeas proceedings are purely civil. The habeas proceedings are unique in nature. And we've cited to a plethora of cases, Supreme Court cases, courts of appeals cases. I mean, the Supreme Court has expressly said, look, we've referred to this as civil in the past. The O'Brien court readily acknowledged that. But when push has come to shove, the Supreme Court has repeatedly refused to treat habeas actions as civil in nature. Harris against Nelson, when the Supreme Court expressly said, look, the civil label is gross and inexact. These proceedings are unique. And so I would quibble with Your Honor's suggestion that habeas proceedings, simply because they stem from an immigration civil matter, makes the proceedings themselves somehow also civil. I think that's not what the Supreme Court has said about habeas actions when push has come to shove. Certainly, there is a plethora of case law that has loosely referred to them as civil, mostly because they're usually distinguishing these cases from criminal cases. But when push has come to shove, and the Supreme Court has been forced to reckon with whether or not habeas is included in civil action, it has repeatedly refused to do so. That would be my, I do think that we are.
Yeah, let me just follow up with one last thing and then I'll cease and desist. When O'Brien was talking about term any civil action and holding that it was ambiguous, it held it was ambiguous as to criminal/civil hybrid cases. It wasn't ever talking about a case where the underlying detention was, and I don't think you've really answered that.
Your Honor, I definitely agree with you that the court did discuss that, but that's not all it discussed. As I mentioned before, it also disapproved of the reasoning from the cases which had applied EJA in the immigration context. It expressly disapproved of Hill as the case exhibiting, quote, spotty adherence to the waiver of sovereign immunity. I don't see how you can read that as any way other than disapproving of what the Ninth Circuit did in Hill. I also would point out that it made a distinction. Look, O'Brien Court was very much also concerned with looking to the substance of the remedy. And in doing so, when it distinguished the cases in the immigration context from the criminal context, it explained what the Ninth Circuit did in Hill and what the Second Circuit did in Sotelo Akije. The substance of the remedies in those cases did not involve custody. O'Brien's case is different because it does involve a challenge to custody. Well, that's exactly what we have here. So O'Brien's reasoning, I agree with you, it discussed that part of the hybrid nature was in part contributed to by the fact that often these cases stem from criminal proceedings. But it didn't say that the nature of the proceedings would change if they stemmed from a civil context. And when the court went on to address the immigration-related cases, it disapproved of them and it distinguished them in a way that supports the government's position here. So I would, in answer to Your Honor's question, don't stop reading just at that one paragraph. There's a whole lot of analysis more from O'Brien that's readily applicable. And that really gets me to the larger theme here, which is it is the reasoning of the entire decision that is controlling here. That's why the district judge found that O'Brien was controlling. It wasn't just that it had found that EJA wasn't applicable to habeas proceedings, and that is certainly broad language, which Your Honors have already noted, certainly seems to indicate. I think that broad language is telling in the fact that it knew other circuits had made the distinction that the petitioner is making to ask, and it refused to make that distinction. That was what, if you read the district judge's decision in this case, that is the reason that he determined that O'Brien was controlling. That's why he relied on the decision. So I see that I just ran out of time. Do Your Honors have any further questions? Well, in that case, thank you very much for your time. I appreciate it.
Okay, thank you, Mr. Robbins. Let's have Mr. Mirsky wrap it up for us.
You're on mute.
Thank you, Your Honor, and apologies.
Wouldn't be an argument if somebody didn't do that once.
I had to finish it out the right way. Just three points on rebuttal, Your Honor. First, I'd like to pick up where opposing counsel left off. I think saying that this court is bound by O'Brien's reasoning is wrong or misleading at three different levels. First, stare decisis does counsel's deference to past mistakes. It provides no justification for making new ones. And the Supreme Court has repeatedly refused to extend reasoning that it disagrees with to the extent that it's no longer applicable. Second, I think it's just worth noting that it's an extremely odd position for the government to take. I mean, the government, in the course of most of his oral argument, has not really defended the underlying reasoning of O'Brien and has not really argued why non-criminal habeas petitions should fit within the context of any civil action. Instead, it's mostly just saying, follow O'Brien. But if O'Brien's wrong, I mean, that I think just illustrates the sort of inadequacy of the government's argument. And then, of course, the final point is...
Wouldn't we also have to say that Schlanger is wrong? I mean, Schlanger's a habeas case, but civil in nature, right? This is a soldier who says he's being held against orders or whatever the facts were. It's a civil habeas case to the extent there's a different kind. It's a habeas action in which the underlying facts are civil. And the Supreme Court there says that is not a civil action for purposes of this statute, right? I mean, to me, that seems maybe even more powerful than O'Brien, when we sort of get to the question of is it, and it certainly is on the ambiguity point, because in Schlanger, the court then turns to legislative history and says, we don't get anything from legislative history. And we know that they only are looking at legislative history if there's ambiguity.
Yeah, so Judge Richardson, a few responses to that. The first is that Judge Douglas's cryptic footnote, I mean, of course, is dicta. Going beyond that, I mean, what Judge Douglas actually did.
We tend to follow the Supreme Court's dicta. We may not follow our own dicta, but we tend to follow the Supreme Court's dicta. What
Justice Douglas did is precisely what I think we're asking this court to do. Justice Douglas didn't say the phrase civil action is ambiguous. Justice Douglas looked at the legislative history and concluded based on the legislative history that for that particular statute, the phrase civil action did not encompass habeas proceedings.
No, but what he says is, and I just had it, but I lost, he just says the legislative history doesn't give us a hint one way or the other. And so therefore it's excluded. Right? That's not saying the legislative history dictates it, it's saying the opposite. You got that?
Respectfully, Your Honor, what he says is that the legislative history does not suggest that the phrase was meant to encompass habeas petitions. And so I think the way we at least read that.
Which means that the language on its face does not, and nothing in the legislative history puts it in.
Well, respectfully, I don't think that's clear. I think the question that Justice Douglas was looking for is what was Congress's intent? But even if you're right, Your Honor, I think all that shows is that, number one, a case that post-dates the use of the phrase any civil action, so therefore I don't think could have affected Congress's understanding of the statute, found in that particular instance that the indicators of congressional intent went one way. And we're asking this court simply to look at the exact same indicators of congressional intent. The legislative history here in this particular case is very clear, right? I mean, the government expressly represented to Congress that the phrase any civil action would cover cases like this one. And so to the extent even that you're right.
That's the canon. Then we get back to the canon problem. And I understand your Richland argument, but then we're saying based on legislative history, we're finding this unequivocal waiver?
Not just legislative history, Your Honor. I think it's also purpose. I think it's precedent. I think it's importantly the use of the word any before the phrase civil action, which was not present in the Schlanger, in the relevant statute in Schlanger, but tells this court that the broader meaning, whatever the broadest meaning of civil action, is the one that Congress meant to enact in EJA. And so I think all that put together, along with the Supreme Court's unbroken record of saying that habeas proceedings are civil in nature, is everything that this court needs to know before it even gets to the sovereign immunity canon. And Judge Keenan, to that point, I mean, footnote 10 in Vacchio, I think really lays out the proper analysis of how to approach the sovereign immunity question in this case. The question is not how can we read the statute as narrowly as possible. The question is, applying all the tools of statutory construction, do we have an answer, or is it still ambiguous after all that? And respectfully, I just don't think that after applying those canons here, that there's any way to come out other than to rule, as every other court of appeals to answer the question has ruled, that non-criminal habeas actions are in fact civil actions within the meaning of the EJA. Thank you, Your Honor.
All right, thank you very much, Mr. Mirsky. And the court would like to thank both Mr. Mirsky and Mr. Robbins. You've done an excellent job today, both of you. And you've also assisted us in making this argument technologically possible. And for that, we're very grateful as well. So thank you very much for your professionalism and for your good attention to your respective positions. At this point in time, I'll ask the clerk to adjourn court.
This honorable court stands adjourned until tomorrow morning.